Study number 2 is titled Statistical Inference to Legal Argumentation. It will be presented by Robert Patel. Mr. Patel is the Director of Legal Technology and Systems Management for the New York State Attorney General's Office. He is often sought after for his advice on the use of science and technology in legal matters. However, his primary responsibility is to manage technology that we consider one of the nation's largest law firms. It's my pleasure to introduce you, Robert Patel.
I've been dispensing free legal advice because I'm not an attorney. I thought I should set the record straight. I'm not an attorney, nor do I really consider myself a statistician, although I use statistics in all of my work. Now, primarily, what I do is to look at network statistics and budgetary statistics, making very neat arguments based on both sample surveys we conduct as well as a variety of other areas. But the area that I want to talk about today has to do with my interaction with attorneys. I guess I need because I know where I come from, but I really should begin by thanking you all on behalf of Attorney General Dennis Vago for inviting the Attorney General's office here. We think that it is very important to talk about the use of statistics in particular and science in general in law cases because increasingly science is playing a big role in cases. The Attorney General's office has 1,800 staff people, got 800 attorneys, and a large number of those cases involve issues such as environmental law, that are actually our scientists who are working on those issues. We deal with criminal areas. We deal with a tremendous amount of personal litigation in civil areas, a tremendous amount of liability. Because, as I was saying at lunch, when you hit a side rail going down the thruway, the state thinks that it protected your life. You think we damaged your car. And when you litigate, invariably you'll bring in an expert witness to talk about skid marks and we'll bring in experts to talk about the amount of rubber on your tire and on and on. And a great deal of litigation occurs in just this fashion. Now, I'm going to speak in part of prepared remarks. I apologize for not having slides, and a lot of slides itself are well slides, but please bear with me. You need to know a little bit about how I specifically get involved so that you can test my knowledge as an expert on the subject. And generally, I'm not brought in as an expert witness in a case to talk about rubber or oil spills or who had a smoking gun. I'm brought in because that expert witnesses are first expensive. And so before an attorney has a case, it might be a good idea to talk to someone with a little bit of background, statistics and science and technology in general, to see if there's likely to be a case that could be treated by these issues. And I'm free, and the expert witnesses aren't, so they call me. Well, so I act as a sounding board so that attorneys can make this determination. You should know that I've been involved with lots and lots of cases you've never heard about, but many that you have heard about. I've worked with the tobacco litigation team and the Microsoft antitrust team, both of which are multi-state cases in which New York State is taking a lead role among all the states. I've looked at cases arguing that Oxford Health Fed improperly manages finances, that Mobil Oil has harmed the environment, that America Online built its internet consumers. And as I've already mentioned, I looked at a lot of cases where the state itself is acting as a defendant against prisoner claims. We have a major case called the Campaign for Fiscal Equity with the state of New York, or excuse me, the city of New York, is taking the state to task, saying the state, the legislature, unfairly allocated education money. They should have gotten a bigger part of the pie over the years. Having fiscal organization. Now, I've seen all of these cases. I know a lot about them, but I have to give you my regrets. I can't talk a whole lot about these cases because they're being actively litigated. Cases go on for years and years and go to appeal. So I just can't give you a lot of detail about those specific cases unless I have a slip of the tongue, which I don't do. I can talk about some other cases. I can talk about some classic instances that have some similarity. What I would like to do this afternoon is provide a little bit of background about how expert witnesses are used in court cases, how they're used to introduce statistical testimony in particular. And I'll cite some examples of where courtroom statistics have gone awry and discuss how they've given rise to several proposals to improve the way science is used in legal disputes. And finally, I really thought about this in the shower, I'd like to talk about mathematics teachers and how you folks can directly influence active court cases, especially on appeal, and indirectly shape the outcome of future cases by who you teach. And this has been great. I'm sorry that I can't stay longer than, for the rest of this conference, but this has been very enlightening to me. Just talking to the steering committee last night, listening to the presentations this morning, it's given me a lot of ideas on some problems that are really key in jurisprudence. Well, at the outset, I have to state that there's a fundamental difference in how courts approach scientific facts. Now, scientists might want to pursue questions of fact. Let me give you an example. I can talk about this because it's over. It's a hearing rather than a trial. A hearing has quite the same evidence rules. One of the state agencies had an employee that had gone through all sorts of progressive discipline. They wanted to get rid of him. And this guy was not showing up for work. Excessive sick leave, he just wasn't there. And I said, we've counseled him, we've gone through all the stages, it's time to get rid of him. So the agency fired him, sent a letter, went to him, and there was a hearing. Civil service, there's a binding arbitration in civil service in the state, so we went to binding arbitration. And the attorney was arguing the case. Here's his work record, he didn't show up, really easy. The opposition said, well, he's suffering from clinical depression. You shouldn't fire him. He has a medical condition, he should be treated. So the attorney called me and said, I wish I really had some knowledge of clinical depression and some arguments to lay out there, because they're going to bring an expert witness in next time that's going to testify in this area that I know nothing about. So, actually, I want to hear that. As I was saying, about 80% of the work that I do is in serving that, because there's so much out there. So, I read a bit on clinical depression, and I found the fact that in most cases, the vast majority of cases, I can't quote the numbers because they're over my mind. But in most cases, people suffering from clinical depression are getting drug therapy, and in 6 weeks are able to return to work. And I said, thank you for the chart, send for those numbers, I'll go in, and when the expert witness comes, I'll challenge him. Clever attorney. He said, now, you've indicated, cross-examination, you've indicated that he's suffering from clinical depression. This person should have been able to return to work very quickly. Of course, the scientist said, yes, in a standard case, but this is a special case. This person's going to be out for a very long time, very deep depression, require special drug therapy. It will go on for years and years. The arbitrator stopped the hearing, called the attorneys together and said, you know, it's pretty clear that this person can't work. So there was an agreement between the attorneys. They gave the guy 6 more months, and he was gone. Now, note here that the question wasn't the facts of whether or not clinical depression was curable, and the length of time it was curable, what the probability of this individual has being able to return to work quickly. That wasn't the issue at all. The issue was trying to get, this particular attorney's approach, trying to get the opposition in a corner so that they would admit that indeed the person couldn't work. There is this waltz that science and attorneys do together. Science is very useful when it supports your case, and maybe not so useful when it doesn't. And you always have to turn it a little bit. That's not what scientists do, it's not what statisticians do, because we're seekers of truth. At least that's what we think we are. Well, okay, so modern science deals with statistical probabilities and never gets past theories of how the universe is constructed. We only have theories. Science achieves enlightenment by trying to disprove the theory it posits. We try to negate the theory. That's how science is done. And science tries to say things that apply universally. We try and show what the meanings are. The law is not like that. Our justice system is aimed at judging whether some individual acted rightly or wrongly in a single instance, a sample of one. It charges juries with drawing final conclusions beyond any reasonable doubt. And you know, you've heard a lot of the views lately about the different preponderance of evidence and reasonable doubt. There's not a whole lot of difference, because those things are ultimately in the mind of the judge and the jury. So beyond a reasonable doubt, you say to a jury, there's a 99% chance that this event happened, that this is the guilty guy. The jury thinks there's a 100% chance that maybe he's the only one who doesn't fit the mold. Okay. A scientist who fails to express doubt, by contrast, is not well considered. He's considered a dogmatist in the field of profession. Whereas courts try to establish causality, statistics posit only strong correlations. Trials end while questions raised by science go on forever. Good science draws inferences from all the evidence. Adversarial atmosphere of the court, good lawyer draws inferences by selecting only those points of evidence which advance the client's case. So we got this contrast. So it seems that science should never be brought into court. Why would the jury ever want it there? Well, you might think there would be no place. But I think that would be wrong. In every phase of the case, experts are involved in the trial of facts. In fact, in the legal profession, trials are called trials of facts. And many attorney manuals provide advice that opponents' statistical arguments are very easily impeachable. The instructions on how you can do this. But they've got this contrast. Okay, now, let me tell you a little bit about how a trial is put together. Maybe those who saw the trial in the press recently, there's court TV. But let me just review this. It's a trial, it's not just a trial. You got these phases. You got investigation, you've got discovery, you've got trial, you've got penalty. And investigation involves independent collection of information about suspicious acts. So typically the work of law enforcement, corporations also go through periodic investigations in the form of audits. ensure that its funds are being properly handled. And if they find they're not, they go after that individual that they think are responsible. One of the responsibilities of the Attorney General in our state is to register charities, real estate ventures, and securities dealers. Now, registration involves the submission of legal, financial documents to the state annually, sort of like a tax return. And we run statistical models against that data to try and figure out whether there are points that, whether there are issues in the data that might point to fraudulent activity. Such analysis has been called by one of our bureau chiefs the means of identifying the boutique scam of the season. Because, as it turns out, it seems that, certainly not all charities, but those charities that are involved in fraudulent activity seem to use the same scam, and they change from time to time because they're using the same account in some new ways. So the model are able to identify these patterns. In consumer frauds investigation of online services, we've set up computers which you can call Prodigy and CompuServe, for example, randomly, to sample how frequently the consumer might get a busy signal. Something that interests lots and lots of people. And these efforts are used to determine, for example, whether there's a problem which might have generated a complaint to a state attorney general's office by a citizen. And the complaints themselves are the subject of analysis as we examine our own phone logs to determine whether there's a rising trend in one criminal area or another. So, investigation is one aspect of court cases. It's got a tremendous amount of involvement in sampling, in examination of statistics to try and identify whether there may be areas that deserve the attention of the Attorney General. The point of all this, of course, is to determine whether to file charges in the course of law, court of law, and thus only for a formal case. If a formal case is over, then we move to the second phase of the case, and that's discovery. Discovery is where parties in a dispute lay out the evidence for each other. You don't surprise, aha, you do know. That's how it happens in a court case. Before anyone gets into the trial, the attorneys share with each other information that they're going to present. They share evidence provided that the opposition is asked for. In a case where expert witnesses will be brought in to talk about scientific facts, an experienced lawyer will ask his opponent to produce all statistical evidence. The expert witness is used to draw preliminary conclusions, an explanation of the method used to arrive at inferences, and references to academic literature supporting all underlying postulates. Why does he do this? I'm trying to get him. Because he knows he can engage in an argument, a scientific argument, in the hopes of disproving some of the knowledge that's brought to bear. Consider the following expert of discovery motions. They have some sense of what in discover an attorney might ask an opposing attorney. Here's one from a case involving DNA testing. Just a short answer. Discovery should include, upon request, copies of autorads, the opportunity to examine the originals, copies of laboratory books, copies of quality control tests run on material utilized, copies of reports by the testing laboratory. It goes on to ask for the publication of supporting theories involved in assessment, the names of other experts in the field, explanation of methodology, and so forth. There's a lot of data here. There's a lot of data sets here that is being asked for. And as you might suspect, it's during discovery that a lot of cases are settled just on the basis of those facts. Well, okay, it's not a discovery, it's a little bit after. In the next phase, you go to trial. And the first thing you do in a trial is you get a jury. Now, you look at the evidence, you look at the jury. You look at the evidence, you look at the jury. Then you decide whether you want to settle. In the trial phase, you have a situation where pre-trial hearings fail to reach a settlement or confession. Juries are summoned to make a common man's assessment of the facts. A common man's assessment of the facts. graph, the common man's assessment of these statistical arguments. And that's very important. It's critically important in our justice system that ordinary men selected from among the citizenry without prejudice sit on juries, and that they evaluate the claims of competing parties, and that they not bring their own prejudices themselves to it. In cases with complex scientific arguments, the jury's ability to correctly decide has been called into question. Okay, the final phase, the penalty phase. We'll get back to that issue. The penalty phase is where you, in civil cases, primarily, draw on statistics to play perhaps the most preeminent role, the most powerful role, than in any other phase. In class action suits, for example, the actual harm of each and every victim might not be known. America Online was challenged in several states for having sold unlimited access to the internet, but then failing to provide sufficient means for customers to make local phone calls to America Online facilities through which the internet was accessible. And they lost in lots of states and settled in many states. Incidentally, because they're one of the states, I can talk a little bit about this. America Online calls us now before they change their policies to ask, are you going to sue me? I think quite so. The Attorney General is very proud of that. When you have potential opponents calling you to straighten things out beforehand, say the taxpayers a lot of money, there are a lot less victims, and that's the way the law is supposed to work. Things are not supposed to go to trial. They're not supposed to go. They're supposed to settle early, and in most cases do. Well, to determine the amount of time all customers are deprived of access requires inference. Inferences drawn from fewer sample points, which are representative of the whole population. And here's where sample collected during the investigation brought back into the assessment of the penalty. Let me say, I'm making this up, but say that 50% dial telephone, 50% of the time get a busy signal, an attorney might argue in court that America Online should return to consumers half of what they paid during the period of question. So a lot of this type of thing is brought in, lots of these arguments are brought specifically in the penalty phase. One of the interesting statistical cases in recent memory is that the Minnesota tobacco settlement. All the states are settling. I know you read the Senate is trash. The tobacco bill, but it doesn't matter. All the states have got their own cases going. Now, recall that Minnesota was successful in having Philip Morris turn over a raft of internal documents for discovery, in which, in these documents, the company repeatedly made a connection between nicotine and addiction. Okay. After that, the state didn't have any obligation to show any correlation between addiction and nicotine. It didn't have to try and get to causality from correlation. Very little thing to do. And it didn't have to talk about cancer and smoking and addiction and all of these relationships. Philip Morris did it for it. Philip Morris admitted guilt at the trial, then turned on assessing how much damage the tobacco company had caused and how much it would have to pay in payments. At one point in the proceedings, I think I'll have to start with that. At one point in the proceedings, the tobacco company expert examines the graphs which the plaintiffs have introduced. The graphs show the confidence interval of the sample reporting to show the number of nursing home-related deaths from tobacco-related illness and the costs associated with it. Blue Cross and Minnesota is one of the places so the key interest in assessing the damages which could be compensate nursing homes and therefore back to the insurance company. The tobacco company argued that a prudent approach in assessing the damages, after showing that the state actually showed a lot of different studies that were not exactly the same, They went out and they surveyed and had records on everyone who's suffering from these problems. They surveyed this acid process, came up with some indication of what portion of the population smoked and had these problems and what the likely cost was. And the state did several of these, the federal government did several of these, and the expert from this bathroom country said we're all different. They don't all draw the same conclusions. They draw about the same conclusion. And when you look at the confidence intervals from him, he suggested to the jury and the judge that, the prudence should be brought to bear here, and probably, we shouldn't be 95% accurate here. We should have a much larger margin of error. And when we actually talk about cost, because it was dollars that were being applied, we probably should go on the low end of the confidence. That seemed reasonable. And in this instance, the jury didn't buy it. And so there's a very large settlement in that case. Well, you might say, why does the tobacco company bother to do this? I mean, a couple percentage points. A couple percentage points turns to millions of dollars when you actually talk about the assets. Maybe no other cases in recent memory have made the public more aware of statistical evidence than the O.J. Simpson murder trial, in which he was acquitted of criminal charges, and the civil trial followed, in which he was found responsible for the wrongful death of the murder victims. Expert witnesses played a prominent public role in these actions. It might seem there's been a new dawning of science in the legal scene. In fact, expert witnesses have played a major part in litigation for the major part of the century. In 1927, the federal courts specifically laid out rules for judges to follow in determining whether expert testimony was admissible. And expert witnesses were used long before that. Jeff, the old wagon wheel there, you normally build wagon wheels this way, or the Cooper is wrong. It's a long time witnesses have been brought in. It's more recently that we get involved in scientific and statistical arguments and complexity, which the neighbors have trouble handling. Now, there's a very important point of law associated with expert testimony, and I'd like to discuss that in a moment. Most testimony given in depositions and trial examination is about a witness's direct experience with the case. The sporting goods clerk remembers that this guy came in the middle of July and bought a ski mask. And the neighbor saw, his neighbor carrying around a gun that looked very much like the gun that was used in the holdup. And the co-worker observed the defendant on the phone, making calls, planning a trip to South America. These are all direct evidence. I saw this. And hearsay is not admissible, and opinions are not admissible. An ordinary witness may not say, that the judge will throw out the testimony, that the defendant's actions are similar to other crooks that he's met in his lifetime. Testimony to the effect that the defendant fits a profile of a criminal manic depressive. Nah, I don't care. That's your opinion. It's inadmissible. Yet, this is exactly the kind of testimony that is admissible when it's presented by an expert. Experts have special standing in the court of law. Scientists and mathematicians are well regarded in the legal system. In a 1974 sample of 1,400 judges and attorneys, where they were asked, what do you think about science in the court? 75% of the respondents felt that scientific evidence was more credible than any other type of evidence. It's contrasting. I want to impeach all of these statistics, but I find it very reliable. Problem. And maybe it's because attorneys have higher degrees, appreciate the academic life. Scientists come from the academic world. Maybe there's some camaraderie there. Cameron and Ed wrote in 1979 about this Scientists are seen as disinterested, open-minded, impartial, emotionally detached, supremely rational. I like the way this quote finishes. And possess scrupulous mental hygiene. Which transcends ideology, politics, and self-interest. I don't want to show hands on this, but I wonder how many of us here have very strong feelings about the death penalty. I mean, really strong feelings about the death penalty. And I wonder which of us, if testifying as experts, would let, in a capital crime, would let those feelings intrude. I'm asking that. I pose that as an internal question, part of our mental hygiene. Important question. The courts recognize experts as experts pure, but we are individuals and humans. It certainly begs the question, how does the court know an expert when it sees one? What's the standard of testimony of an expert by which an expert is judged? When experts disagree, how can a jury sort out the fact from fantasy? Let me set the stage for some of these issues. I'm referring to a capital case in Elkhorn County, Mississippi. An expert witness was asked to test two pieces of rope. Each rope was stained with an unknown material. The expert was asked to determine whether the material was the same on each rope. The expert testified that the first was stained with a substance that was a complex hydrocarbon. On the second rope, the expert reported that it too was stained with a complex hydrocarbon. Now you have to understand this, since you're all complex hydrocarbons. You, each and every one of you, by this testimony, was implicated in this capital crime. Complex hydrocarbon. Okay, now, testimony was good or rubbish, provided no hint of whether the substance on each of the ropes was the same in common sense of the word. Obfuscation. Charlatan scientist's roots, however, was only exposed on appeal. The top trial judge, or the parties in the dispute, or most importantly, the jury saw through the hoax. This guy was convicted on this evidence. This expert's evidence. But there wasn't fear. Consider another case. Sort of classic case, one of my favorites. This is Seville and versus the state, also the state of Mississippi, tried in 1981. This was a rape and murder trial in which human hairs found on the victim were compared with those of the defendant. Joe Andrews, the Mississippi Crime Lab, incidentally, and all of these things where I mentioned other states, the blues, it's other states, it's not New York State. Okay. Andrews told the jury that the odds of finding two people with matching pubic hairs would be 1 in 800. And scalp hairs would be 1 in 3,500. Andrews predicated statistics, by the way, on a study that he said was conducted in Canada among subjects, all of whom were Caucasians. Canada, Caucasians, using this in Mississippi. And no argument was made why this study was applicable to the local population. There were other studies looking at things like blood types that showed substantial disparity in different areas of the United States. Much aggressive remote. You see a lot of medical facts, medical studies done this way. 12 lower class Hispanic women in a Brooklyn hospital researched, and we find that these drugs work on them, and we got a new drug. That's a very strange set of sample points. It's similar here. Something happens in a study happens in Canada, and we try and immediately carry it into another locality without proving the fact that they might be related. It might be related. It might be appropriate, but not on the surface. Well, Sanders stated that while one hair matching the known sample had moderate odds, the number would go up if more hairs on the victim could be matched. I knew I liked this story. I usually have to get to the conclusion before I get a rise. But listen to the court dialogue. The prosecutor, I should do this with a deep southern accent, but it probably depends so much. The prosecutor says, now, as you responded, about 1 out of every 800 people might have one similar pubic hair. Is that correct? The expert witness, yes, sir. Prosecutor. And you said that if you had 8,000 people, it might be 10 people to match. But consider this. If you had 2 pubic hairs that matched, would that make the odds 1 in 800 times 800? We've got an expert witness, so we know what he's going to say. This is normally the way to multiply statistical values. You have a certain set of events, and each one of those has a statistical probability that will occur. And if you want to consider both of these probabilities together, then you multiply your 2 probabilities by each other to achieve your final probability. Prosecutor says, so if my arithmetic is correct, instead of being 1 in 800, that makes it about 1 in 64,000. Okay, so at this point, the defense counsel rises, raising an objection. He clearly sees that something's wrong. He knows. Unfortunately, all he sees is his opponent can't do calculations in his head. So he raises an objection. He says, Your Honor, I want to object to leading the witness. Counsel is reporting statistics which the witness has not raised. See, the attorney gave the answer. He was supposed to say, "Would you multiply these together?" Defense counsel blusters. He says, Your Honor, let me correct that. He addresses the witness and says, do you have something to write on, or can you do 100 times 800 in your head? And the witness said, I believe that would be 640,000. So that would be the odds, 1 in 640,000. Yes, sir, that's correct. With just 2 pubic hairs. Yes, sir. And in addition, there were chest hairs. Yes, sir, there were other hairs. There were chest hairs recovered from the shirt. There was chest hair recovered from the sample of the victim at autopsy, and there were 2 pubic hairs. Yes, sir. And does each one of these additional findings increase the odds? Go by the multiplication of probability? Yes, sir. I guess it does if you go by the multiplication of probability. Okay. Of course, using the expert in this guy's product rule, 12 matching hairs, the chance that Belleville, the defendant in this case, was not guilty becomes 1 in 10 to the 34. Since there are only about 5 billion people on the earth, he had to be the guilty guy. Of course, you could use the product rule if the events were random. The odds of heads or tails is a half, and the odds of 2 heads is a half times a half quarter. Yes, sir. But you can rarely say the same thing about a crime scene. All of the evidence collected in the crime scene is one event. There's no randomness. In fact, police don't even randomly go out and try and find the perpetrator. The victim says he was a tall, bearded man with graying hair. And the police go out and they look for tall, graying men with beards. And when they find one, they try and find out something about him that matches the crime scene. It's not generally good with science. It's the way you do an investigation. It's try how to try and catch a man and condemn him to injustice. Well, so then what do you do about the misuse of statistics in the courtroom, where none of the participants have adequate knowledge? In 1927, as I mentioned before, in the case of Fry versus the United States, the principle was established that there would have to be some measure by which a presiding judge would determine whether expert testimony is admissible. The standard included an expert must be properly educated in the field about which he is to testify, and he must use principles which are generally upheld in the scientific community. I visited the scientific community on a vacation once. I think it's in Florida. It's a fine community. But, so there's always exceptions to record rule, I suppose. So the classic case cited to discredit this approach involves the community of 3 experts in voice string detection. 3 consultants, these 3 guys in the expert testimony trade, published a number of articles in which they claimed that the positive identity of person could be established by statistical comparison of sound frequencies from an unknown recorded voice to those of the defendant. And in court, each one of these guys would cite each other. So the community, 3, were referencing each other on theories that they invented. In fact, there's no validity to this kind of voice print. It sounds good, but it's scientific. In many, many cases, went out without the benefit of discovery, because the attorney never asked to see the data sets. They didn't want to see anything. It went specifically on the judge's evaluation of admissibility. They were trained. The scientific community agreed with what they said. They were acknowledged in their field as being experts. Well, in 1983, the rule of admissibility in federal cases was changed. Instead of relying on the phantom community of scholars and the mere fact of publication as evidence of an expert was in the court, judges are now required to directly evaluate the science underlying presented facts. The judges, they don't like this. So in federal court, the justices are now expected to understand the precision of the expert, or they may throw the case out, and throw the testimony out on the case. What a judge can say is, all of these statistics and all of these reported facts by the experts are very confusing, and they will confuse the jury. So I summarily throw them out. We're going to settle this case on the other facts presented, which is sort of contrary to what you'd expect. You want this evidence, the true evidence, to come forward. Some say that the problem is with expert witnesses. We need to have better experts come forward. And on the face of it, some experts receiving $200 to $300 an hour plus expenses, it seems that there is an incentive to come forward. But it's not quite a bit. There are people focused on expert witnesses in cases where there's a lot of liability. In general, there isn't a profession of expert witnesses in every area. So it's really important to stress in meetings like this that some of you may want to come forward and become expert witnesses in some of these cases. It's a little, it may seem a little capitalistic the way you become an expert witness. You put an ad in the paper, the American Law Journal, the ADA Journal, various things, say, I'm an expert in this area. You need me. But really, there is a need for folks educated in these various areas for identifying themselves, because they will be victims by the judicial system. Others say that the fault lies with the judge. Judges need to be better educated. And of course, most would point to the jury. In fact, on the Simpson trials, there are many observers who suggest that the court system resort to professional jurors to get the common man role. Let's have professional jurors, people who are trained in this. The problem is to establish a monarchy of jurors and have people who are go to these special arbiters, sort of like judges, to determine whether a case involving science is involved. Now, someone suggested that it might be a good idea for jurors to be asked to read Larry Donnick's cartoon guide to statistics, or lying to statistics. It might not be a bad idea. It did occur to me this morning when I heard talk about conveying concepts rather than formulas. Maybe it isn't such a bad idea to put juries who are going to be involved in statistical cases with just the kind of course that you're talking about. I can't be law courts, but you can deal with just the concepts, because court trials basically do deal with the concepts and not so much with the formulas. So there's a lot of right thinking in terms of court cases. Well, at this point in my talk, I was going to turn to chatting about the importance of education of mathematics, increasing the knowledge of the general public, so that when people go before juries, certainly in their personal affairs, they're better able to evaluate information. But I thought, as I listened to folks here, maybe there's another point to be made, one that talks directly about what role you, as educators and students, can have in the justice system. What came to mind, I'm trying to formulate these ideas as I talk about, so I can quickly turn to the questions, if you tell me, what came to mind was, in Superior Court of California, a decision was made in one class of trial involving securities. All of the evidence, all of the data sets, all of the testimony, everything that came out of discovery in every court case, except for that it was sealed, some of it does get sealed, will be made available on the internet. Well, this is interesting. Why do courts want to do this? They want to do this because a lot does happen on appeal. And one of the controls over expert testimony can be if people look at that data, the general public looks at that data. You know, poor Judge Vito got a lot of, here you get bandstanding, and this didn't have to be a big television event, but what he was trying to do is put the facts before the public so they would be discussed, and that certainly succeeded. Those facts can't be discussed. They're constantly discussed. You can't turn the televisions on without people reviewing the O.J. Simpson trials. And it's actually a result of that California Superior Court decided it wants to put lots of statistics out there like this. Now, it occurs to me, and here's my question, does it make sense to you, but it makes sense to you as educators, to be able to review that kind of case, look at real data sets, because there you would not only be educating a generation of people who can handle this data, but your students may very well be actively involved in reviewing the statistics that appear in these various cases. And because things can be appealed, you could actually shape the outcome of cases. I think I'm going to stop there. It's an interesting idea for me. Does that make sense to you? Thank you.
We've got just a couple of minutes here. If anyone has any questions, we've got maybe 4 or 5 minutes for questions.
Yes, in a court of law, you have a judge, and I assume what a judge judges is the law. That is, there are these two advocating attorneys, and the judge judges sort of umpires the decision of the law. Why can't there be a similar individual appointed by the state who would be equally trusted to be impartial, who can deal with scientific evidence?
That's very interesting, because just that suggestion has been raised among jurists. You know, the courts can appoint experts, but generally those experts inform the judge himself, so that he knows whether or not the testimony is admissible. But what's been raised is, should the court appoint an expert who is an educator, who will explain to the jury, interpret to the jury what these facts are. Now, lawyers, the entire legal system is based heavily on precedent. So an idea like this is raised, and folks say, well, I've never done this before, let's not do it. But some things like this may very well occur.
I'll throw one at you. In another state, I was called to jury duty.
Yes.
And it was another employment where I didn't have all this free time. all I had to do was say, here's my master's degree in mathematics, equitable science. And I was summarily dismissed by both attorneys. Would you explain why? It worked for my boss. I didn't have time to be there.
Same thing happened.
Yeah, but you work for the firm too.
Well, it doesn't mean that I have time to
I'm not really making fun of the court system. What I'm saying is, there I had the opportunity to invite me on the jury, either side.
It's a contradiction. It's a real contradiction. You expect that you want people who can evaluate this knowledge. Of course, what the jury is supposed to do is only look at the facts presented. So I would bet that the counsel was saying, this guy isn't going to look at the facts as I present them. He's going to draw his own conclusion outside of the case, and that would be wrong.
You mentioned that a judge can summarily dismiss you. This evidence cannot be considered.
Interesting.
And that decision having been made, is that appealable? Is that
Yes.
grounds for appeal?
Yeah, everything's appealable. Everything. It's a court check and balance in our jury system. But everything isn't taken on appeal. So the appeals court doesn't have to hear it.
I was wondering how you envision, say we did have trial transcripts of expert testimony or summaries of expert testimony on the internet for a case on appeal. How do you envision, I mean, I'm intrigued by that, the idea of working with graduate students or advanced undergraduates or myself reading that. How do you envision the input from the academic community working in that case?
I don't know. I honestly don't know.
Okay.
But it's intriguing. I think that government, the Attorney General's offices have to open up and provide means to receive that information. And a filtering mechanism as well. It doesn't exactly eliminate the problem of, is this guy a testament, an expert? I mean, it's a crack bomb.
Well, I'm not going to say you expect to look at dozens of crack bombs for every reasonable reason.
But I think it's certainly intriguing. A way of in the old days, centuries ago, the trial was the entire community. Everyone sat there and knew everyone. Now, they're in small groups. And what courts are trying to do by exposing things to television audiences is trying to get back to a larger jury. Not a jury of boxing, but back a jury of citizens. So that what we all see happening in courts, we all agree is just. And this is a big deal. This is just a method that I haven't seen discussed before, except in the Superior Court of California. So I think it bears some consideration. I'm going to go home. Tell guys at home, maybe we should follow this.
Expert witnesses, unbiased, I happen to know Herb McDonald, and I think he's classified as an expert witness. Tremendous ego. I'm wondering how much egos will get in the way of accurate testimony.
They currently do. You look at this case with the pieces of rope. What was trying to be demonstrated there? Really, not that there was something being, a piece of fact being presented. This guy was trying to show that he was a scientist. Hire me again. I think it's certainly problematic. that's why things like this can help get a wider audience.
Fortunately, we're out of time. One last question.
Do you find they want people like mathematicians or whatever on juries or not? I had the opposite thing happen. If you had a college degree, and when I said I got statistics, I knew I was dead, I was gone. This was a trial I didn't last. We were 3 months FBI, criminal case, both defendants were lawyers. And the minute you said you had a degree, especially in mathematics, you were picked. And then, so he's saying the opposite.
You know, it gets up to the, all the
Well, I
law.
was, I was coached by my lawyer friend where I worked, what to say. You know, what do I want to do? He said, if you want to do this,
It's the lawyer who's making the judgment.
yeah.
Is someone with this knowledge going to help my case or not?
Oh, lawyers said I was not going to help this particular.
Well, both sides decided this is a federal case.
Very different, in different cases, like what the evidence is.
So there's no, you don't see a trend either way, depends case by case.
Thanks very much.
Thank you very much. Before we make our transition to our next session, we're going to take a brief moment to have someone explain to you what the questionnaire is. Is it a green questionnaire, Mark? In your folders. And I would proceed that with a question. What do you think the probability is that at the same time the steering committee is wondering how to survey those of you that were here, we should get a request exactly to do such a survey from one of our participants? Well, it did happen. And Suzanne Goodrich from Herkimer Community College has put together a survey that she's going to talk to you about. Suzanne?
Thank you. Actually, it was put together by myself, John Pearson, who works with me, Bob Johnson, and the steering committee, so I can't take full credit. But it is this green sheet, and it's sort of as self-explanatory at the top. However, maybe you face the same problem. At our college, we talk technology, but when we go to ask for money, it's not fair. Having been a science chair, I recognize that probably the administration would listen more to numbers and responses like this if I could present the rationale. So, the front of it is general information. Answer as much as you can. You may only have one course at your college, you may have 2 or 3, but if you're only familiar with one, that's all I need information about. And on the back, it's more about the technology. And again, try to just answer what you're familiar with. You don't need to know everything in detail. And certainly, I think there's a box where these go. We would
With that
appreciate,
shape to the top of it.
right. I would appreciate as many responses as I can get. And John and I will work on collating everything and making sure you get the tally. Hopefully, somebody else will make use of it like we're going to. Thank you.
Did you want addresses or something at the bottom here?
Bob is going to give me this.
Did you check in? Did you
Yes.
correct your address?
Yes.
I am going to give Suzanne a copy of that. As you will get a copy of it on paper, I'm going to give her a disc with it on so she doesn't have to retype it. So she will have your mailing addresses, and she is going to, I understand, when she has it tallied in total, she's going to mail every one of us a copy of her
But you see
findings.
on the very bottom of the last page, it says, please print carefully colon, and then there's, wasn't sure if I was supposed to write something in there.
That was probably a re-edit or something.
Okay.
You know how it's,
Okay.
you write it, you rewrite it? I don't remember.
Okay.
Is this a detailed guy or what? Go ahead.
Yes.
Just for clarification, maybe you don't want to, but on a survey, I would like to be sure I know what I'm answering. And on use of technology, do you require the use of a calculator? Does that mean institution-wide in the instructor course, or are you asking if I personally?
In your course. Because you might not know what everybody else is doing.
I mean, in our course when I teach it, or our course when everybody teaches? Because I'm in a position where some do, some don't. Do you want to-
I would say what you do.
Okay.
That's the only way I can address this, is what you personally know. That's why I said, although I might leave place here for 3 courses, if you don't know anything but exactly what you're teaching, that's all I need to know. Okay? Thank you.
Okay, Bob has some other information he wants to pass on to us.
Give each of you a blue sheet which shows 4 things. There are 4 different kinds of things that you may save on your disk from the M drive. There is material on there that deals with Excel that Paul Zeitz is doing. There's material on there that deals with my sessions. There's material on there from Pat Kuby's sessions. And there are data sets on there from the case studies. If you go on to the M drive in that look-in box, you go to M, under Courses, under Math, under Beyond the Formula, you will find a directory for Excel or a directory for cases, or just under the Beyond the Formula, you will find Pat's and my material, and you may copy them off using any file manager at any computer on campus. Okay? So those are the addresses. Without the addresses, you may have trouble finding them. For Kuby's and mine, you will also see there at the same level of directory as Beyond the Formula, you will see our name. That's stuff for our classes. Okay, the stuff for us for this conference is all under Beyond the Formula. Okay, so that will give you the location, and then you can copy them out of there for your disk. Okay?
Any questions about? Okay. We're heading on to session number 2. That's on page 3. This time, for the first choice, you'll get some choice. And you'll see under session 2 are listed 4 sections. These are going to be conducted all in Building 11 and various classrooms on the first and second floor. So it's your choice as to what you will pick of those 4 sections. And then session 3 is run the same way. There will be 4 sections there that you'll get a choice on. And then at the end of session 3, we'll sort of become informal, and you see the evening program begins. And so that's where we're about to go now. If I'm not mistaken, right after, in very, very small print, it said refreshments are again available in room 103 in case...
Before you break, David, make sure you understand the 4 sessions at 3:15 and the 4 sessions at 4:15 are run by the same 4 presenters are involved. You don't have to go to the same presenter. You may go to a different presenter. They are presenting something different, but we think we have them stacked up so you can take any those 2 hours, and it makes sense depending on where you're coming from, what background you have, etc., and so on. So you do not have to stay with the same presenter. You may stay with the same presenter. It's total free choice. Okay?
Okay, thank you, Bob. And that'll do it.